All right, good morning, and I am working on your notes for Article 2 and 3, and you should be pulling up the assignment from Moodle, and um, the title should be Executive Branch Enforces Laws. Uh, it should look something like this. Okay, that. And then it also has Article 3, Judicial Branch Interpret the Laws. All right, let me put that back over there. And let's begin. First of all, we got the targets. We're going to analyze the powers of Congress and identify those powers that are delegated, concurrent, and reserved. We're going to discuss and assess the importance of the Elastic Clause. And finally, we're going to analyze the powers of the executive and judicial branches. We're actually going to do this one first. So let's move forward. We've already spent time looking at Section 1 from the Constitution on uh, about the executive branch. So we're going to focus in on 2. And you can see at the top, Section 2, you can see we're talking about the presidential powers. And right under that begins with Commander in Chief. And the president controls the military forces, and the power extends to having control of national and foreign policy in war and peacetime. One of the ways that he can demonstrate this power is through executive orders. And executive orders are something that the president can do, and they literally are making law. And if you'll notice underneath this, it says executive order, and please put there by executive order the term this phrase power of law. And that's true. This is the executive orders from the president is the same thing as law, and we are expected to obey. Now let's move on. Congress may not restrain the president's power in issuing pardons and reprieves except in impeachment cases. Um, oh, by the way, there's a spot on there that says Supreme Court. Get rid of that. I don't know what I was thinking when I put that in. The Supreme Court does not belong there. All right, so, and then also the president, and this is not on there, and you do need to note this, president has the power to appoint federal judges. And this is extremely important when it comes to especially how people or how the laws are interpreted. What kind of judge is going to be interpreted? Will that judge be conservative, be liberal, or be, kind of the middle of the road? So this is a very powerful thing that the president has in terms of powers for him. Okay, Section 3. President must deliver to Congress an annual address known as the State of the Union address, and this is given in January. And since we are in January, I will be expecting you to watch this. The date I don't know yet. It's usually the third week in January. I will let you know, and I do want you to be paying close attention to that. All right, so President may summon Congress into extra or special sessions. Right now, with the fact that the government is closed down or shut down, this is especially true. The president may poll Congress should they decide to go out and ask them to be into session, extend their sessions. This is something the president does have power for. Now, what we're looking at here when we talk about appoint federal judges, as well as some in Congress in the extra sessions, this is for the executive branch, their balance, checks and balance with regards to the legislative branch, as well as the judicial branch. Okay. All right, Section 4. The President, Vice President, and all civil officers in the United States shall be removed from the office on impeachment for and the conviction of treason, bribery, and other high crimes. So the expectation is that, again, anyone in the United States is expected to pay attention to the rule of law. Nobody is to be above the law. Now, that doesn't mean that that doesn't happen sometimes, unfortunately, but it is the expectation that all people are to be expected to follow the rule of law. Now, with impeachment and the conviction of, that means they shall be removed from office. They cannot maintain their office if they have been convicted. Right, let's move on. Article 3. Okay, Section 1. So Article 3 is all about the judicial branch, as it says, and their job is to interpret the law. This article empowers the courts to decide cases and limits them to the exercise of certain kinds of jurisdiction, meaning they have only certain areas that they can work within. If you remember, we talked about jurisdiction before, where we talked about how jurisdiction is all about, where they are allowed to hear the cases. And the best example of this is juvenile court. Juvenile court has power with regards to people who are kids who are 17 and younger, right, up to the age of 18. And that's their jurisdiction. That's where they have power over. So this is talking about where the jurisdiction is. Now, in particular, we are looking at the Supreme Court because that's the only court the Constitution has identified. They have given the legislative branch the power to make more courts, but they did not give them the power to rule over those courts. They can add courts, but then it's up to the judicial branch to then work with each and every court. All right. So as I said, the power of the jurisdiction of this section that we're talking about is the Supreme Court. Right. So one of the first powers that the Supreme Court has is known as judicial review. So the power of judicial review was assured or guaranteed by the Supreme Court in the case of Marbury versus Madison back in 1803. And what it did is it gave the court the power to decide if a law is constitutional or not. Now, if it's not constitutional, then it can no longer be a law. And once the court has decided that, then that law is disposed of. If it is constitutional, then that law continues. So this is an extremely powerful and important power of the judicial branch. The next part of this is the justices or judges are given life tenures, meaning they cannot be removed from office for any reason except a high crime. They have the job for life or until they retire or die. And again, it says unless they are impeached. All right, so that gives them a great deal of power over a long period of time. Section 2 then establishes what kind of cases can be heard by the judicial branch. Certain cases may be brought directly to the Supreme Court without having been heard by another court. That's very rare, but it does happen. Most cases heard by the Supreme Court are under appeal, and that's this next session. Under this statute, the Supreme Court also exercises what's known as appellate review, and that is the right to review any and all decisions of a lower court or state court. They are the court of last appeal. They are the last resort, however you want to say that. When they make a decision, it stops. That's it. That's done. Now, you can continue to appeal other cases, but within that case, the case is done. Okay. Anyone accused of a crime has a right, in this section also guarantees anyone accused of a crime has a right to a trial by jury, except in cases of impeachment, and this right, the right to a trial by jury is further defined and strengthened by Amendment 6, 7, and 8. We'll look at those in the future. Section 3, then, this clause limits Congress' ability to define treason or to set its punishment as a means of preventing political offenders from being charged as traitors. At least 2 witnesses must testify in court that the defendant committed a treasonable act. So this clause basically says that if you disagree with something Congress is doing, as long as it's not against the law, and then you should not be in any way charged or accused of treason just because you disagree with Congress or the courts or even the president. So just because you are, as it calls here, political offender, meaning you don't agree, doesn't mean you're a traitor. And then one thing, additional thing they added to that then was that there had to be at least 2 witnesses that testify in court that you committed this treasonable act. This was in reference to the King of England. He was great, or she was great, at throwing people into prison because they agreed or disagreed with anything they said. And if that happened, you might end up in prison forever. But in this case, this prevents that from happening. The last thing we're going to talk about here is what's known as public policy. And this is something that we are going to have an assignment on, but you need to understand what public policy is. It's the means by which a government maintains order or addresses the needs of its citizens through certain actions defined by the Constitution. These principles are often unwritten, but are often the basis on which social laws are created. So many laws are traced back to this idea of public policy. And it is, as it says, it generally is unwritten, but it does guide. It's kind of the, I hate to say the popular way of seeing things, but in a way that is part of it. Public policy is generally not a tangible thing, meaning you can't touch it, but rather is a term to describe a collection of laws, mandates, or regulations established through a political process. So, for example, the issue of Obamacare. There are tons and tons of laws and mandates, regulations, all of it are established as a part of Obamacare. But the public policy, the whole idea of it is, we call it Obamacare. So that is this hopefully gives you that idea of what public policy is. All right, so we're going to stop there for this section, and we'll continue on next class.